right, so we're back from the coffee break, and we will now move on to an insolvency-related topic, namely the field of avoidance law, that is to declare the old Actio Pauliana, to those who are more familiar with Roman law. Those who remember, it's about transactions that are deemed void under the auspices of insolvency law, and this is regulated by an overarching regulation at the European Union level. I think it's Article 16 for the European Insolvency Regulation. And speaking to us will be Sebastian Mock. Sebastian Mock teaches company law and business law at the Wirtschaftsuniversität.
Vienna University of Economics and Business.
Vienna University of Economics and Business, which is another university in here you find near the Prater. Sebastian is, no, just to locate.
Yes, sir. Yeah,
that's fine. And Sebastian has come to present on this incredibly interesting topic. Thank you, Sebastian, for being here, and we're excited to listen to your talk.
Thank you, Chris. Thank you very much for having me. So as Chris pointed out, I'd like to speak about legitimate expectations and certainty of transactions in European insolvency law. So what I like to cover here is, after giving you a short introduction, I will talk about the risks and the opportunities for contractual partners of the debtor in insolvency, or before insolvency actually. And this topic is at the moment very relevant for shareholder loans, which brings us a combination of debt and equity we heard before. So, and there's a pending case I will talk about at the European Court of Justice that might change the landscape here tremendously. So, where to start? We see insolvency law, or insolvency law is a fundamental element of the creation of the European Common Market. It was from the very beginning, so it became very clear that we need at least some kind of harmonization or coordination of insolvency law, because in insolvency law everything changes, or insolvency proceedings everything changes. So it's very relevant actually where you have your insolvency proceedings and which law applies here. And we see here a rather high level of regulation on the European level. We have the European Insolvency Regulation of 2000, which was renewed or reformed in 2015 and replaced by the European Insolvency Regulation 2015. And we also see at the moment a rather broad harmonization attempt or approach by the European legislator trying to harmonize huge parts of insolvency law by directive. So what's the problem here? What's the problem I'd like to talk about? The problem I'd like to talk about is that if you look at the current kind of regulation, or the regulation, the European Insolvency Regulation 2015, you see a lot of technical regulation for the insolvency of the debtor, of course, and for the creditors, but there's actually something missing, which I will point out in a second. And you can see this focus of the European Insolvency Regulation if you take a look, for instance, in recital 5 of the European Insolvency Regulation. So what's the European Insolvency Regulation is all about? Well, and you see here to avoid incentives for parties to transfer assets or to obtain a more favorable legal position to the detriment of general body of creditors, forum shopping. So these are the two major aspects the European Insolvency Regulation tries to prevent. And so where's the problem? Well, the problem is what about the contractual partners of the debtor? So do we find anything there in the European Insolvency Regulation? So we see a lot of stuff about the debtor, we see a lot of stuff about the creditors, but what about the actual contractual partners of the debtor who close contracts with the debtor before the insolvency? And one could point out, well, aren't these contractual partners and the creditors are the same? Well, I don't think so, because the interests of creditors and contractual partners are not necessarily the same, especially if you look at it from an ex-ante perspective. So in the moment you make the contract, you close the contract, so where you're not yet a creditor, but you hope for a certain exchange with the debtor, That's why you close the contract. And a creditor is something different. That's actually the person that has to get some or wants to get some money from the debtor when insolvency proceedings are opened. So this is not necessarily the same, and we will see in a second. That's very interesting that the European insolvency regulation doesn't really address the interest of contractual partners, and this becomes very relevant when it comes to shareholder loans, which I mentioned before. So from this point of view, or for this thing that we don't see much about the contractual partners, we see a lot of risks for them, but we also see some opportunities for them under the current regime of the European insolvency regulation. So let's start with the risks. And what are the risks for the contractual partners under the current regime? Well, I will show you this in some kind of cases or hypos. Let's say we have a debtor. It's a German corporation, natural person, doesn't really matter. So we have a German debtor. And let's say we have a contractual partner from Italy, and they close a sales contract, whatever kind of contract, and they include, of course, a choice of law clause. So which law should apply, Italian, German, whatever law. And then let's say we have a shift of the COBE, center of main interest, of the debtor from Germany to Portugal, which is possible because we have this very broad freedom of establishment, which was established by the European Court of Justice in a large number of cases, Centros, Überseering, Inspire Art, and so on. So for businesses especially, you have this freedom of establishment, and so you can go wherever you want. And this means for insolvency proceedings, since insolvency proceedings are not opened at the place where you were registered, but at the place where you actually are, where the center of main interest is. So this can change, and so you can shift the COMI, like in my case, let's say from Germany to Portugal. So what does this mean for the Italian contractual partner of the debtor? Well, interestingly, it doesn't really mean much, because now we don't have insolvency proceedings opened in Germany, but we have insolvency proceedings opened in Portugal. So this is the approach of the European insolvency regulation. So wherever the insolvency proceedings are opened, you can, as a contractual partner, as a creditor, you can go there and enforce your claim there. So that would mean, in this case, you would have to go to Portugal to enforce your claim in these Portuguese insolvency proceedings. And so there is no clear legal disadvantage because the claim stays the same. It doesn't change anything. Well, of course, you have to take into account that you have to go to Portugal, or you have to go have to find a Portuguese law firm or whatever. But if you see the case, it doesn't really change much for the Italian partner, because before that they would have gone to Germany. Now they have to go to Portugal. So it might be a little bit more expensive or less expensive, but there's actually no clear legal disadvantage. Well, this is of course the case, and this is what the European insolvency regulation had in mind. So we have this freedom of establishment, shift of COBE, you can go wherever you want. It doesn't really change anything. Well, if you take a closer look, this is actually, if you take a closer look, this might be a problem. If we take the same case again, and we say we have a German debtor and we have an Italian contractual partner, and again, they close a sales contract with a choice of law clause. But now what changes? Well, this contract has not yet performed. So it's still opened from what either side or both sides. So the contract hasn't been performed yet. And let's say now the German debtor moves or shifts the COMI to Portugal. Well, what happens? Well, in this case, a lot of things happens. Why? Because the insolvency administrator in the proceedings, they can, usually many insolvency laws have that, they can choose whether to perform or not to perform this contract. So, but this rule of law is, this rule is not the same in all insolvency laws in Europe. So you have large differences, which kind of contracts in which kind of contract this rule applies, what actually the consequences, and so on. So since this choice of the insolvency administrator falls under Article 7, subsection 2, letter E of the European Insolvency Regulation, or the next four causes, so this changes if the debtor moves or shifts its COMI from Germany to Portugal. So for the contractual partner, for the Italian business, well, this means that the applicable regime changes actually. And this creates, of course, some uncertainty, because as long as the contract has not yet been formed, you don't know where you end up in insolvency proceedings, but because you don't know which insolvency law applies, because the debtor can move and the debtor can change that. So you can even go further, and this brings us to the case I mentioned with the shareholder loans. This is a case actually at the moment pending at the European Court of Justice. We have a debtor, a German closed corporation, and we have a shareholder, which is an Austrian, also closed corporation, but it's a shareholder. Doesn't really matter that it's also a closed corporation. So we have an Austrian shareholder, and the shareholder gave a loan to the German corporation, and in this loan contract, they made a choice of law. They choose Austrian law for this loan contract. Okay, so and then later there was a repayment of that loan just before the debtor became insolvent. Okay, so and now the interesting thing comes here in this case. If you let's take the Portuguese aspect out. So the German debtor, if insolvency proceedings are opened in Germany, then German insolvency law applies. Okay, so then the question is this repayment of the loan. If this falls under avoidance law, then German law would apply. So under German law, in this case, this transaction was void, or the repayment was void. Under Austrian law, under Austrian avoidance law, and Austrian law, it was not. So the question here is, and how do we qualify actually shareholder loans under the European Insolvency Regulation? So if a shareholder gives a loan to a closed corporation, is that lex societate, is it lex four concursus, or is it lex causae? And if you see the different approaches, and if you take a look at the literature, you can see almost every solution that's possible presented there. And if you say it's a lex societate, so what does it mean? That means that the debtor is a German corporation. It stays a German corporation wherever it goes, even if it goes to Portugal. So if you say shareholder loans are corporate law, then this doesn't change. Okay, but in that case, it would mean that the repayment would be void, and so the shareholder has to repay the repaid loan. If you argue it's lex four concursus, which in my hypo then would be Portuguese law, then you would have to ask yourself, well, what does Portuguese law says on that? So if Portuguese avoidance law says if a shareholder gets the loan back just before insolvency, then is that void or not? So here again, we have this uncertainty because you don't know as a shareholder where your corporation ends up, in which country, where the COMI will be, so they can change that, so the regime will change. So even in the moment where you claim your loan back, you don't really know whether this would be void or not. Or if you say it's lex causae, which means that since they choose Austrian law, that would mean that very comfortable here for the Austrian shareholder in that case, because under Austrian law, which is easy to be determined for the Austrian shareholder, they can say, well, is that void under avoidance law or not? And if it's not, so I claim my money back. And even if the debtor falls into insolvency proceedings are opened, I don't have to repay that. So we see this, as I said, this case is pending at the European Court of Justice. It was filed this year, as you can see. So whatever you argue here, whatever the outcome might be of the European Court of Justice, you have a possible change of the applicable regime. So which creates a lot of uncertainty for the shareholder, because as I said, not only at the moment where you close the contract, where you give the loan, but also at the moment where you actually claim the repayment of the loan, you don't really know which law actually applies, whether this would be void or not. So far for the risks, let's take a look at the opportunities this regime holds for contractual partners. If you, again, take a German debtor and a contractual partner, again, an Italian one, and they close a contract, the same thing. And here we have a performance of this contract in violation of German avoidance law. Then, interestingly enough, the European insolvency regulation provides an exit because even if you then again have the shift of the COMI to Portugal, then in this case, Portuguese avoidance law would apply. That's what the European insolvency regulation says. But this, again, would create this uncertainty for the contractual partners. But in this case, actually, the European insolvency regulation provides an exit, as I said. This is Article 16, according to which you can claim, well, whatever avoidance law is applicable, it doesn't matter as long as under the lex causae, the avoidance law of the lex causae, this act is not void, then I actually don't have to repay what I received from the debtor. So you can actually use lex causae as a de facto, or the lex causae has a de facto blocking effect in avoidance law cases, which of course brings us to the question, why do we have that here, while we don't have it in general in the European insolvency regulation? Well, the idea of Article 16 is here to protect the legitimate expectation and the certainty, and provide certainty of a transaction. This is what recital 67 of the European insolvency regulation tells us, and this was confirmed or underlined in a series of cases of the European Court of Justice that dealt with Article 16. So you actually have an exit. So as long as you have an lex causae that actually says, okay, under the avoidance law of the lex causae, the act is not void, then you can claim the repayment and you're fine. Well, let's go back to the simple avoidance law case. What would that mean if, again, we have here our case, and again, we have this performance in violation of German avoidance law, then, again, Portuguese insolvency law would apply, which also would ask the question, what does Portuguese law say on avoidance in that case? But this doesn't really matter, because then the question would be, what does Italian law says in an avoidance law? And if Italian avoidance law says, okay, you cannot reclaim it back, then you're fine, no matter what Portuguese law says. So there is certainty for contractual partners because you cannot change the regime, actually, because you have always this fallback option. Well, under the applicable law, under the lex causae, I'm protected, or I can take a look if I reclaim or if I ask for a repayment of the whatever it is of the performance. I can take a look at the avoidance law of the lex causae and ask myself, well, is this performance in violation of the avoidance law of the lex causae or not? And if it's not, I'm fine, no matter where the debtor actually goes. Okay, so the debtor can shift his COMI wherever he wants. It doesn't matter, because I always have the defense of the lex causae, and as long as I'm fine with the lex causae, everything is fine for me. Well, this is not new so far, but what becomes interesting and now is if you take a look again at this shareholder loan case, because there in this shareholder loan case, another point steps in, and if you again take the case, we have this Austrian shareholder, the German corporation, and they gave this loan to the German debtor, and then they repay the loan just before solvency. Well, as I mentioned before, you have to ask yourself, how do you qualify these shareholder loans? Is it corporate law? Is it insolvency law? Or is it a contract law? And so can you actually apply Article 16 here? But then again, a new point comes in, which is Article 9 of Rome I regulation. And this case was initiated by the Federal Court of Justice of Germany. And it's a very odd case because, as I said, the debtor filed for insolvency in Germany, and we have this Austrian shareholder, and they repaid the loan just a few weeks before the insolvency, or a few months before insolvency. And according to the shareholder under Austrian avoidance law, this is fine. And the insolvency administrator in this German proceedings claimed, well, this is a violation of avoidance law, or under German avoidance law, this is void. So the shareholder claimed here, well, Article 16 applies, and since we have a lex causae, the Austrian law, then since under Austrian law it's not void, so you cannot ask me to repay the loan. But then the Federal Court of Justice asked the European Court of Justice in this proceeding, well, even if this is the case, what about Article 9 Rome I regulation? Okay, so is avoidance law overriding mandatory provisions? And the interesting thing is, the Federal Court of Justice said in this case, where it transferred the case to in this judgment, where it transferred the case to the European Court of Justice, the Federal Court of Justice said, well, I think it is. Interesting thing is there was no actually references to anything. They just said avoidance law in total is an overriding mandatory provision. So even if Austrian contract law or Austrian lex causae, Austrian law applies via the lex causae, so Austrian avoidance law would apply and would say, well, we have this blocking effect. There's no, the transaction is not void. Then we would have to ask ourselves, well, is then German law again actually avoidance law an overriding mandatory provision? So we will see how this how the European Court of Justice will rule on that. But you can see here, obviously, if you allow that, then you're back to square one. Okay, so you go from German insolvency law to avoidance law to Austrian avoidance law, and then back to German avoidance law. So this case draws a lot of attention in Germany. Why? Because if this really works out and the European Court of Justice actually dismisses this Article 9 Rome I regulation argument, then this would actually be the end of the regulation of shareholder loans in Germany. Why? Because then you can always opt for, if you give a shareholder loan, you can always make a choice of law rule in the provision in the loan contract and say, well, we choose the application of a very shareholder loan friendly law, where obviously the Dutch law actually seems to be very attractive to that, because they don't have, that's what people tell me, I'm not 100% sure, but that's what people tell me, they don't have anything on shareholder loans when it comes to insolvency in Dutch law. So there, many people are afraid that this very huge and nice and not so old regulation on shareholder loans and insolvency law, which was initiated only in 2018 after a very long debate, very long and intense debate, that this whole thing actually be finished because you can actually circumvent it by choosing a lex causae, which is actually very shareholder loan friendly. So this is the one thing I wanted to point out. The other thing is more general, and I think this is something which becomes relevant now if you take a look, a broader look at the European insolvency regulation and on the interests that are addressed in the European insolvency regulation, and especially taking into account that the European insolvency regulation is not only applied in pure or classic insolvency cases, but also restructuring law cases. Well, then we have to ask ourselves, okay, what about the interest of the contractual partner? we see in Article 16 of the European Insolvency Regulation, there is this idea to protect their legitimate expectations and to provide a certainty of transaction, but it's only mentioned in Article 16. And the question I'd like to raise is whether this is a broader principle actually, or whether we have to be more sensible when it comes to the interest of contractual partners, because of course you cannot make contracts actually to avoid the insolvency event. But the problem we have in the common market in Europe is that you cannot even tell in most cases which law actually applies. And if you close a contract, you'd like to know that, okay? So you'd like to include or make this clear. So even if your contractual partner goes bankrupt, you'd like to know which bankruptcy law applies. And at the moment, you don't know at all. And so the question is whether Article 16 is actually, as I said, a broader or larger actually principle. Because if you look at the interests of all other parties involved in insolvency, you see the interest of the debtor. We have freedom of establishment, so the debtor can go wherever they want. They can shift the COMI, and by this also shift the applicable insolvency law. And we see this very often. We saw this especially before the Brexit, but also since the Brexit, we can see that corporations, large corporations, shift the COMI in order to go for a country where they have a better insolvency regime. So there we take care of the interest of the debtor because we allow them to move around, of course not to choose insolvency law, but the consequence of this freedom of establishment is actually that they can choose the applicable insolvency law. We see the interest of the creditors, especially by the principle of lex fuerum causis, and which depends on the COMI. So the whole principle of COMI, or the whole idea of the COMI, of center of main interest, is that we open insolvency proceedings where the creditors actually are, where they have where they have a business relation and everything, so close to them. So we take care of their interest, and we also take care of the interests of the debtor and the creditors. Maybe we'll see what the European Court of Justice says. By this overriding mandatory provisions in international contract law, Article 9, Rome 1 regulations. So we see here that we have a problem actually with these legitimate expectations and certainty of providing certainty of transactions for the in the interest of the contractual partners, because we see that the interests of other parties are taken care of. And so I think we should be more sensible when it comes to the interests of the contractual partners, and maybe think about broadening the scope of Article 16, or see Article 16 as a general principle where the interests of contractual partners are more protected. So that's for me. Thank you very much. I'm happy for your questions.
Thank you, Sebastian. Sebastian has challenged us with three intersecting arbitrage choices, as you've seen. One, the applicable corporate law through incorporation. Second, the applicable insolvency law through center of main interest. And then third, the lex causae contract law applicable to, say, a shareholder's loans contract. Thank you so much. Other questions? Noreen.
Thank you very much. I've very much enjoyed your presentation. I appreciate that the focus of your research paper is on EU insolvency and shareholder loans. I just wanted to say that in the context of my research, I also came across this and sort of seeing a lot of shift of COMI. We're seeing, at least in my research, I saw a deliberate change of governing law from 3 jurisdictions, specifically German law to English law, New York law to English law, and the sort of more recent trend is Hong Kong law coming to English law for all these reasons that you were mentioning. And so I wonder whether there is like a bigger story there where you can potentially widen the scope of your paper, also saying that this is not specific for EU. This happens within EU, but there is this bigger trend of arbitrage on a more global scale. And at least in my experience, I was looking on the sort of funds doing these things.
Mhm.
And my research showed that there's a lot of shift from New York to England, from Hong Kong, and from some continental European jurisdictions to access Part 26
Mhm.
schemes of arrangement in UK. Raises lots of interesting questions. But yeah, I just thought this is very, very interesting, and whether there is a wider scope.
Yeah.
And why are we seeing this? Yeah.
Yeah.
Thank you so much.
And the interesting thing is, as you mentioned, we see this, what I mentioned before, before the Brexit, we saw this a lot with England, and especially German corporations used that a scheme of arrangement going to England. After the Brexit, it becomes a bit more difficult. Some still do it. But we see this especially within Europe and also between Germany and Austria, actually. And so very often you have this, of course, you have some fractions of these cases are abusive cases. They just shift the COMI to a very strange jurisdiction. So where nobody knows what's going on. And then the creditors basically have no chance to actually exercise their rights because it's way too expensive. Let's say you move your COMI to Lithuania, okay, or something like that. Yeah, or Bulgaria. So we see these cases, but this is usually abusive cases. And then we see this constructive cases where they actually go for jurisdiction because this jurisdiction provides a very certain tool they'd like to use, which actually is missing in their own jurisdiction. And the European Insolvency Regulation tried to address that when it was reformed in 2015 by providing the creditors a right to object this opening of insolvency proceedings. But I think you have to do it within 2 weeks or something, and usually you don't notice within 2 weeks that the COBI was, or the insolvency proceeding was opened, because we don't have this central register. They're working on that now on European level. So, but then again, the question is whether all creditors actually look into that. Okay, they don't usually. And so if you go at the moment of the homepage of the European Commission, they have a list of all insolvency registers of Europe. So what you can do theoretically, you can click through all 27 and look, yeah.
I do that.
Yeah, and I use that, but I guess I never tried that, but I assume that probably for 50% of them you have to register before you can do that. So
yeah. Awesome.
So I enjoyed your presentation a lot. Thank you. I had 3 comments/questions. One is, I mean, the first one is really, I mean, as a policy matter, I wonder, should it matter for what reason a particular transaction is voided? And it could be voided under insolvency law, right? An avoidance action, but it could be a violation of rules on shareholder loans, right? Equity substitution, or it could be a violation of legal capital rules. I feel like it shouldn't matter as a policy matter based on the creditor's expectation. Second question is, what can creditors do? Do they have any option to protect themselves? I mean, I think this seems important because it's also their reasonable expectations, right? And it seems that the Article 16 gives preference to the reasonable expectations of contract partners, right? And not necessarily other creditors. And third, maybe we do need a more radical solution, maybe a new European insolvency regulation. I remember many years ago when I looked into this, I think John Armour, he suggested at some point that we should think about making COMI basically identical to the place of registration, right? Would that solve things, or but I guess that might not be possible under the current framework.
Yeah, start with the last one. I totally agree. Wouldn't be possible because you have to sacrifice freedom of establishment in a way. So you have to get rid of one of the 2 principles, and both are very valuable. So this is not going to happen. What they try to do at the moment on the European Commission is to harmonize avoidance law. And they're working on that. And they are very far with that. So, but I have my doubts actually, because if you look at the drafts that exist so far, this is basically a copy of the German version of avoidance law. So, and since this working group was led by Professor Borg, he's a German law professor, okay, who's obviously listening. So
he's amongst us now.
He's amongst us now, yeah. So they actually made a proposal which is very close to German avoidance law. And the problem of avoidance law is that avoidance law is much about policy. So avoidance law is very different from jurisdiction to jurisdiction, because there you see certain ideas, values, and political decisions. Okay, what should be void and what not. And I actually doubt that this is going through, but we'll see that. So what was the second question?
Creditors can do.
Yeah. So the idea with Article 16, if you look at the origin of Article 16, the interesting thing is that the idea was not that you actually choose the lex causae. The original idea was that if I'm an Austrian businessman here in Vienna, and let's say an Italian or German comes here and makes business with me, okay, we close a contract, and then this business partner goes bankrupt. Then the lex causae would be determined automatically, not by choice of law rule, but there's an Austrian law would apply. So I'm protected here because I'm from Vienna, from Austria. So I rely that whatever I do here with other people from other countries, actually my avoidance law applies. Well, but this is not what Article 16 says. Article 16 says it's according to the lex causae, and you can choose that. And what they didn't have in mind was that people actually can say, well, I'm an Austrian businessman, you're an Italian businessman, we make a contract and we choose Italian law or Dutch law or Latvian law, whatever. So because under this law, there's no avoidance at all. There are just jurisdictions, people tell me Dutch law seems to have almost no avoidance law. So we can choose that law. And in the case law I mentioned of the European Court of Justice, the European Court of Justice said several times, but only very briefly, that this choice of law might be void itself. Okay.
Exactly. Yeah.
Yeah. But it doesn't really say under which conditions. Okay. This might be the case. It says it's possible that the choice of law is void, but it doesn't really say when and under which conditions.
Yeah.
So this is, there you have the interest of the creditors. Okay, so originally Article 16 had a very narrow scope. Okay, but the wording doesn't reflect this narrow scope. Okay, and so the practitioners actually say, well, it says lex causae, and we have the Rome regulation, which says you can choose your own law. So that's what we do, and you can choose a law that's not related to you. Okay, if we have Italian, German, Italian, Austrian case, we take a Dutch law. Okay, that's it. We can do that, but this is not actually what Article 16 was intended to do. Okay, so. There you have the interest of the creditors. It's a very small extension, and this is how the European Court of Justice understands Article 16. In my approach, it's not an extension, but it's a general rule. But that's the very issue we have to discuss. And the first question was.
I mean, I know, but let me quickly follow up on that. I mean, it seems to me that I was really thinking about the other creditors, right? Not the creditor, not the business person interacting with the company, and it seems like avoidance law exists to protect these creditors who are maybe not in a position to do something about it. You know, they don't anticipate insolvency, right?
Yeah.
And they're not able to choose a law that is strategic with. And I think it's their reasonable expectations that no transfers will happen that are unfair to them in certain ways.
But if you follow that argument, then you have to get rid of Article 16 at all. Yeah.
Maybe.
Because then you have to, I totally agree with you. Okay, so what you, as an Austrian creditor, if you have insolvency proceedings here in Austria, what you expect is that if somebody else gets something they shouldn't have gotten, then you are protected. Okay, so the insolvency administrator will claim it back, and you will get your share of it. But this is not what Article 16 says, you know. So then would you have to get rid of Article 16?
Yeah, many topics to discuss, but we're a bit running out of time. Tim, would you be willing to hold off until lunch break? If that is so, we thank you, Sebastian.